Okay, so this is part 3 in a video series on civil harassment restraining orders being presented on behalf of the Kern County Law Library. As with all videos that are produced by Kern County Law Library, these are for information purposes only. And if you have questions about the specifics of your case, what is best to do under the circumstances for you, you would need to consult with a licensed attorney. These are meant to be general informational videos that would walk you through the procedure that one would follow in Kern County specifically. So parts 1 and 2 of this video series cover whether civil harassment restraining orders are appropriate for you, and if so, how to fill out the paperwork. So now that you've filled out the forms, what do you do? So the title of this video, I've filled out my form, or I filled out my forms out, now what? It's going to cover 3 different topics. Where do I take my forms first? What do I do with them after filing? And then what happens next? Again, this is with reference to Kern County specifically. So there's going to be some information that litigants in Kern County would benefit from. So be sure to keep a close eye on the content here. So the question, where do I take my forms? You should have selected the courthouse where you're going to file as you are filling out your paperwork. Most of the forms that you're going to complete have a blank spot on the first page where you will have written in the court's address. Bear in mind that there are multiple courthouses in Kern County where you can file, so you would want to select the one which is going to make the most sense in your case. Next up, we see that e-filing is an option that you can use through the Kern County Superior Court website, which you can see right here. So if you want to file electronically without the need to visit the courthouse, you may do that. You may always mail your paperwork to the courthouse, but otherwise you will take all of your complete paperwork to the courthouse you selected and find the civil department. Now in downtown Bakersfield, the most heavily trafficked courthouse, the civil department is located at 1215 Truxtun Avenue, Bakersfield, California, 93301. And you will not need to bring multiple copies of your paperwork, just the complete original set of forms, plus your filing fee or your fee waiver paperwork. And we covered that in a previous video. So where do you take the forms? If you want to hand them to someone in person, the civil departments generally operate their filing windows Monday through Thursday from 8 to 4 and Friday from 8 to noon. From Monday to Thursday, they are available with limited staffing from noon to 1. So they really do have 8 to 4 inclusive Monday through Thursday available. So you may also deposit your paperwork in a filing drop box in the lobby of each courthouse. And to keep your paperwork straight, you should only do this in an envelope large enough to fit all of your paperwork easily without bending and damaging it. Bring along a self-addressed stamped envelope if you would like to save a trip and have your paperwork just mailed back to you. So to be clear, that would be a large 11 by 13 manila envelope addressed to yourself with stamps already on it. And you give that to the clerks along with your paperwork. And once they've made their copies of the forms that you've just filed, they can just mail them back to you and save you a trip back to the courthouse. So next question is, what do I do after filing? Well, you should pick up your paperwork from the civil department at the court where you filed, or wait for it to be mailed back to you. The civil clerks will make copies of your paperwork for you, so you only have exact copies of what has been filed and reviewed by the judicial officer in your matter. Your paperwork should be ready within 1 court day of filing, but you can always call the civil clerks to confirm your paperwork's ready for pickup. You're welcome to give them a call just to make sure that when you arrive at the court, you'll be able to pick up your forms and ready to go. So the first thing you should do is read your temporary order, start to finish. You may not have a temporary order in your case at all. It could be denied completely, or you may have one where the court granted you part of what you requested and denied the rest. But the point is, you will not know unless you read it. So you really need to review the temporary order, the CH-110. And then next you should review your notice of hearing, the CH-109. It will tell you when and where your hearing is set. You need to arrange to have that time free because you must attend your hearing. They're not going to consider the petition in your absence. Your matter could be dismissed entirely. So you need to arrange to have the morning free where your matter has been set. Next, you must ensure that the party you are asking to be restrained is served copies of the paperwork. So if you are the petitioner or a protected person in the request, you cannot be the one to serve the restrained person. So in other words, someone's going to have to deliver copies of the paperwork plus some blank documents to the person that you asked the court to restrain. And it can't be you, and it can't be anyone that you ask the court to protect by the order. It has to be someone else. You can always have the civil section of the Kern County Sheriff's Office perform service. You can also hire a registered process server to perform service, or you can also have anyone willing to perform service do it, as long as it is not you and not someone else protected by the order. And as always, they must be over the age of 18. So you must have your server deliver a set of documents to the restrained person, and the documents include your file stamped, in other words, the paperwork processed by the clerks, the CH-100, your request for your civil harassment restraining order, your CH-109, your notice of hearing, your CH-110, your temporary restraining order, and totally blank versions of CH-120. This is how the person restrained by the order can respond. It's called response to request for civil harassment restraining order. You also have to give them an information sheet prepared by the Judicial Council. It's called CH-120 info, or how can I respond to a request for civil harassment restraining order. Next, you would need to give them a blank CH-800 proof of firearms turned in, sold, or stored. Next, what do I do after filing? After your server hands a copy of everything on the previous slide to the person you want restrained, have them complete a proof of service. In civil harassment cases, the form to use is CH-200, proof of personal service. It is your server who signs the proof of service. Filing this form tells the court the party you want to be restrained has been properly notified. There has been a case filed requesting a restraining order against them, and if there are any temporary orders issued. So on to the frequently asked questions. So frequently asked question number 1, when is my deadline for serving the person I want restrained? So the instructions from the Judicial Branch website read, look at page 2 of form CH-109 once you've gotten it back from the clerks. Look at paragraph 6. Now the normal deadline, the standard deadline is at least 5 days before the court date, but if your deadline is different, it will say so on the form, and I'll show you where that would be. So your service deadline is provided right here. This is page 2 of your CH-109. So right where the enormous yellow arrow is pointing is where you would look to learn where the court has ordered you for your deadline to have the other party served. And in addition to your service deadline, the section below that tells you the list of documents that you have specifically been ordered to have served on the restrained party. So this is with reference to your case. The court will have told you what needs to be served on the other party. So items without checkboxes must always be served. And then the items with checkboxes are those which may need to be served depending on what the court did with your specific case. Next up, for frequently asked questions, what if I can't get the other party served with the paperwork? So sometimes the person you want the court to restrain tries to evade service, but nonetheless, if you want the court to issue a restraining order, the party you want to be restrained needs to be notified there is a request for a restraining order against them. Now, the court's strong preference is that a person you want restrained should be personally delivered a copy of the paperwork that tells them about their hearing date, what you have requested, and how they can respond. Again, that's personal service, someone actually handing the paperwork to the party that's restrained. So if you've tried multiple times to serve the other party, you may try attending your hearing and detailing the efforts you have made. If the judge decides you have made a sincere effort to personally serve the restrained party and they continue to intentionally evade service, you may be given a chance to serve them by mail or publication. In other words, putting the information in a local newspaper. Frequently asked question number 3, will the person I want restrained be at the hearing? So they may attend. They may well be there in court with you on the day that you asked the court for a permanent restraining order. Now, if you feel uneasy about being in the same room with the person you're asking the court to restrain, remember to approach a bailiff and mention to them you are asking for a restraining order and the other party may be in attendance that day. So keep in mind, in Kern County, each courtroom has a bailiff that is there in order to keep and maintain order in the courtroom. So just be sure to mention to them that if you feel nerves on the day of your hearing, that you're asking for a civil harassment restraining order and you're worried the other party may attend so that they can keep an eye on the proceedings that day. So what happens if the court grants a permanent restraining order? So you will need to have an order after hearing prepared. That's a special form prepared by the Judicial Council of the state. You can have it done by the Self-Help Center. Just contact them at the email address displayed there in the red text, or dial them at that number and let them know you need assistance preparing an order after hearing for your civil harassment. So some people think that they attend their hearing, the judge says that they will grant the order and that's the end of it. But just like how the individual that was restrained needed to be notified that there was a hearing where you were requesting an order, they also need to be notified that an order was made official and filed with the court that for a period of several years at times restrains their behavior. So another question, does the restrained party need to be served with the order after hearing? Well, the answer to this is read your order. Read your order after hearing, and paragraph 13 should tell you whether you have to serve the person who is restrained by the order and how to serve them. These are instructions from the state's judicial branch website. So again, read your order because every case is different and the instructions to you may be different than others. So you really must review the content of your own paperwork to best understand what's required. Now, if you're ordered to serve someone by mail, this means your server, which again means somebody over the age of 18 other than people named in the paperwork, only has to mail a copy of the restraining order, but serving someone in person is always best. And when you mail court papers, it may be hard to prove that the person actually received a copy, especially if the person moves a lot. So the court will not know the person restrained by the order has been served unless your server completes a proof of service. For this, you would use form CH200 if the restrained party is personally served, and you would use form CH250 if they are served by mail. So we would like to invite you to contact the Kern County Law Library if you have questions or concerns that were not addressed during this presentation or any of the first two. You can always reach us by going to our webpage, which if you Google Kern County Law Library, we should be the top search result. And if you just visit kclawlib.org, you should be able to get our contact information at the bottom of our homepage. You may also, of course, visit during our operating hours. We display those on our homepage as well. So with that, I leave you and say best of luck with your restraining order case. And again, with questions, points of clarification, you may contact the Kern County Law Library either by phone, by email, or during our regular operating hours by visiting in person.